This right here sets the stakes. The judge just mentioned a cap of 5 years. That means no matter how bad this gets, the maximum time behind bars is 5 years. In Texas, that's actually light for a sexual assault conviction, which shows this was a plea deal. But the big question? Will the judge actually accept it, or tear it apart?
Daryl James Ardwan, that's you, present with Mr. Dusler, your attorney and the state's attorney. Earlier, you pleaded guilty to the second-degree felony of sexual assault. A pre-sentence report has been prepared. Have the parties had an opportunity to review it? Are there any corrections or changes to it?
Your Honor, there are no corrections or changes concerning the defendant's version of it. He does have a little bit of dispute with some of that,
Go ahead.
The police version, but
yeah.
It's basically just a difference of opinion. So I'm going to say we have no objection.
All right.
I have no objection, Judge.
All right, then it is made part of the record for all purposes here. And again, the agreement, whatever sentence shall not exceed a cap.
Listen to the defense here. They're painting Daryl as a hard-working dad who made a stupid mistake. This is classic mitigation strategy: highlight remorse, responsibility, and family ties. But notice what's missing: the victim's humanity. When you lead with the defendant's pain before acknowledging the victims, that rarely lands well with a judge.
5 years imprisonment. So, second-degree felony. So, it can be no less than 2 nor more than 5 years. A deferred or unadjudicated probation can be allowed. Is regular probation allowed under these under this set of circumstances?
I'm sure, Judge. It's been a while since I looked at sexual assault instead of sexual assault with a child. Let me look at it.
Well, the complainant was 17, is that right?
Yes, sir.
No. Well, that's it. When 17
It
is.
says does not apply on limitation on judge ordered, does not apply to 22011 sexual assault.
Does everybody agree with that? So it's deferred or unadjudicated probation?
Judge can't give you straight probation.
Or flat prison time. So that's regular probation is not allowed. You're on section what? Yeah.
It's sexual assault.
That is what was indicted in this case.
Yes, sir.
That's what's that? All right. Go ahead on behalf of defense. You may go forward, Mr. Dusler, first. And
we are actually asking for deferred adjudication probation.
Now, the judge is laying out the facts in brutal clarity: oral sex with a 17-year-old who did not consent. This isn't storytelling, this is legal precision. When a judge restates the charge like this, it's not for the record, it's to make the defendant feel the weight of the words he once said, "I plead guilty to."
I've spent quite a bit of time with Daryl concerning this, and he strikes me as a very sincere man who made a very, very stupid decision right before Christmas of last year. As the report indicates, they were having a Christmas party at his apartment with his daughter, a couple of other friends, and the first thing he did that was really, really stupid was providing alcohol for them. They were close to being of legal age, but not of legal age. They never should have done it. And that's the one beginning really stupid thing that happened. After that, he acknowledges that everybody drank way too much, including himself, that there's differences of opinions to exactly what happened. But frankly, he was pretty blacked out himself and doesn't even really recall the exact sequence of events. But he knows that something happened and something happened that should never have happened. He has told me that he totally accepts responsibility for this. He realizes that that was about as stupid a thing as you could do. He's written a letter to the court acknowledging that responsibility. Looking at his history, he's never had any felony of any sort, even accusations of felony. He was on one misdemeanor probation, but that was an evading arrest. It really had nothing similar to this type of offense. He's a hardworking young man. He works a full-time job as an operator at the plant. He's got a bunch of children that he supports and pays child support on. Basically, what he's saying is this was just about as foolish a thing as anybody could do. He deeply regrets what happened. In the recommendations, he does say, I'm truly sorry for my actions. I never should put anybody in that situation. Learn my lesson. It should never happen anything like this again. Hardworking citizen who made a very poor decision. And I think that pretty well sums it up. Again, he's written a letter to the court that I've shown Mr. Laird as well. And if the court wants to address him or ask him anything else concerning it, I think I've kind of spoken to the heart of what you told me. He appears to me to be a very sincere man who is accepting responsibility for something that was horrible. And I think that he's asking the court to give him an opportunity to prove that nothing like this has ever happened. Have I pretty much covered that, Daryl? Do you want to elaborate or just wait and answer any questions the judge has for you?
Let me just ask something here, Mr. Ardwan. Did you want to say anything before the state? No? Okay. One of the things that helps us judges take care of our business is we get the pre-sentence report prepared by the probation office, and they do an outstanding job. I'm very proud to work with them. They help us greatly because there's a lot we don't know. Judges and the lady next door who handle these felony cases, there's a lot we don't know about. We weren't present. So we've got to make an important decision based upon the information given to us in spite of the fact we weren't present. And we have to rely on certain methods, and we rely on getting your opportunity to be heard and listening to you. And then the probation office seeks information from law enforcement who do the investigation. And then most importantly, the complainant, the victim in the case. And then they prepare a pre-sentence report. And this one is 1, 2, 3, 4 pages. And it also has a supervision plan for the court to deal with. We have the indictment, probable cause affidavit, all these things that we look at, so that's really some of the first impressions that the judges get is preparing for this sentencing. Each party involved has a chance to speak. You, at your plea hearing, pleaded guilty to this offense that was indicted, second-degree felony of sexual assault, which alleges that on or about December 22nd, 2024, in Jefferson County, Texas, you intentionally or knowingly.
And here's the moment the courtroom shifts. The judge smells inconsistency, and in court, 2 versions of the truth equal 1 guaranteed disaster. This is where many plea deals fall apart, a defendant who wants mercy but can't commit fully to guilt. You can literally hear the judge's trust evaporating.
Caused the sexual organ of a 17-year-old young lady, to contact or penetrate your mouth without the consent of that young girl, 17. And that's what you swore to and pleaded guilty to. You understand? You were sworn to and you pleaded guilty. So when you go to the pre-sentence investigation, This is what you said. Even though under oath you had pleaded guilty to what the indictment elements were. You say, my daughter and her friends always come to the house. Everyone was drinking. The little accuser you refer to as the victim in this case, my daughters went to get something to eat and she left her behind. We were intoxicated. Everyone was on the couch. She came, this is the victim, sat on the couch with me. We started fooling around with each other and I said, no, I'm not going to do that. She, the accuser, the victim, touched me. The defendant, you admitted to being under the influence of alcohol at the time of the offense and explained that you blacked out and don't remember what you did. That's your version, which was, it's her fault. That was what she did to me. But yet, under oath, in front of me, you had the audacity to plead guilty to intentionally or knowingly causing her sexual organ to contact and penetrate your mouth. Oral sex is what you did. That's what you pleaded guilty to. I don't see any of that admission in here. So are you lying to the probation office or lying to me when you pleaded guilty?
No, sir.
That question right there, how do you give that back to her? Is one of the most haunting things a judge can say. It's no longer about the law, it's about morality. And in this moment, the entire courtroom isn't thinking about sentencing, they're thinking about the irreversible damage done to a 17-year-old girl.
That's exactly what happened. Like I said,
Now, you have two different versions. Which one, if they can't both be right?
When she says that because you were blacked out, you can't dispute that that's actually happened. If that's what she said happened, it had to have happened.
That's exactly what happened.
This is your version.
Yes, sir.
But when you looked at me in the eye and pleaded guilty, we went over all of this. You looked at me, I say, I'm guilty of this. And you were under oath. You're under oath. It's a document that's swearing. You took the oath. You can't have it both ways, sir.
Judge, if I might, state of Texas is not satisfied that he's accepting responsibility for what he's done, and that offer was made upon him accepting responsibility. So we would, at this time, withdraw the offer and ask this be reset for trial.
Judge, I don't think that the state's offer was contingent upon anything, but I do say that he is accepting responsibility for this. He's saying that he was unconscious. He doesn't know exactly what happened, but he cannot dispute that that's what she says. He said, if that's what she says happened, that's what happened. I may not remember it because I was blacked out, but if that's what she says happened, then that's what happened. And that's the way he's related to me. I think that's
What do you have?
that's where we are. And I think the state should be bound by their offer. Because it wasn't contingent.
I think they have a fair issue that's brought up. You can't have it both ways.
He's accepting responsibility.
I'm accepting responsibility. And I guess what I told her.
You're accepting responsibility, but you have two different versions.
I say I was drunk that night. I was out of here.
Who caused that to happen?
I did.
You have, voluntary intoxication is not a defense to any crime.
Yes, sir.
Okay. So that's your problem. You put yourself into. But what we have here is a 17-year-old who was sexually assaulted. Let me ask you this. How do you give that back to her?
Okay.
Her innocence.
Okay.
No. And you're responsible for that, the adult. I don't even know what the price, you can't set a price on it. But one other thing, here before this occurred in 20.
So, 5
You
years in
ended up
prison and a lifetime on the
being
sex
convicted
offender
on that,
registry. But here's the
crime.
real question.
were
Do you think 5
sentenced to
years
1
is
year in the
justice?
jail, then that was
Or a consequence
you
too
were
light
placed
for
on
what he admitted
probation
to?
for a year.
Drop your
That looks
thoughts
like it
below,
was
and remember,
extended
in the courtroom,
for
truth
18
isn't
months.
just about what's proven, it's about what's owned.
And in your pre-sentence report, you had an evading arrest or detention offense charged against you. It was a misdemeanor, and boom, you ended up being convicted on that crime. You were sentenced to 1 year in the jail. Then you were placed on probation for a year. That looks like it was extended for 18 months. And is that right? Was it?
Still
1 year jail, 1 year disposition, 10/9/23, 1 year jail / 1 year adjudicated probation and $1,000 fine, 10/1/24. And then semicolon, 18 months extension. I really don't understand what that means.
Are you still on probation?
No, misdemeanor.
You're off of
Yeah, I'm off probation.
When?
No, I get off probation like in February. But what happened on that?
No. When did you get off of probation for that?
February.
This February?
Yes, sir.
You're getting off or you're off?
I'm off.
Okay. But you were on when this happened.
Yes, sir.
But you were on probation with this, then you committed this offense? Okay. You know, criminal actions have consequences. We made that clear. You were on probation. You were convicted. And so while I'm convicted of this crime of evading arrest or detention, you commit sexual assault on a child, a 17-year-old. I have that right, correct? Okay. The court's going to move forward on this, but
Then, Judge, can I make my argument
yes,
before you do that?
yes, sir, you can.
Because I want you to look closely at that letter that he wrote you.
Yes, sir.
Clearing this all up and how much remorse he had for the child and what he did to her, because that letter is all about him, all about everything is always about him. Even in the pre-sentence report, there's not one thing in there that says, oh my gosh, what did I do to that girl? I wish I could help. I wish I could take it all back. Wish I could give her innocence back.
But here's 3 words. She touched me.
Yeah.
But you admitted to oral sex with her.
And he called her the little accuser. That
I don't recall
just
saying nothing like that. I would never say nothing like that. And I actually, on the pre-sentence, I don't know if she wrote everything down, but I did.
They do.
Yeah. But I did.
They're real good about it, and they're real fair. The probation office isn't
the time
about.
I was there.
Listen, when I speak, stop. Okay. The probation, it's a point I want to make. The probation office has a rich history of being fair. We have a 93% success rate for our probation. You think they're working against you? No. They're trying to get you across the finish line successfully. So don't say it's their fault, sir. They do their job accurately, and they take great pride in success in probations, people making mistakes, fixing it, and moving on and being the best they can be. So
And Mr.
don't
Deuce-
go toward the probation office is dishonest when you got 2 separate sets of statements made to me under oath at the plea hearing, and then here in the pre-sentence report, your words are 180 degrees different, and it tends to blame the 17-year-old. But you do say the right things in this letter. No, I was wrong. I take accountability for my action. I was going through a rough time in my life. Welcome to the world. Boy, don't we all from time to time, but we don't go out and sexually assault 17-year-olds. I mean, there are certain things that with the difficulties we all have every day in daily life, some difficulties affect our clear thinking. Well, it's pretty clear. You don't have oral sex with a child. After there's drinking, and then drinking. Was this at your house?
Yes, sir.
Yeah. Well, who's responsible to applying alcohol to the children?
Right.
You were. Okay. Oh. Okay. The pre-sentence report also states the mother of the victim. My daughter was supposed to be at a sleepover. You were pouring the kids alcohol like they were grown at a bar. And this event has mentally impacted my daughter. There's something else here that's in this pre-sentence report, but it's not. You know what it says. You've read it, and it's not a good thing about your reputation. All right. Anybody else have anything to say? Mr. Ardwan, anything you would like to add?
I just wanted to say I apologize about everything to the mother, to the victim.
Yes, sir.
You know, I never meant for anything to happen. You know.
That's not, well, this says you admitted to intentionally or knowingly doing this, committing oral sex on the child.
Under the influence, you know, I made bad decisions. I made bad choices.
Well,
I regret it all.
Let me just say that these sorts of crimes in this court generally result in the highest form of punishment. And you were looking at this case at no less than 2 nor more than 20 years confinement in prison. And juries regularly give the maximum when they believe the crime has been committed. And this court does as well. Here is the cap. Y'all agreed on a cap. The highest that the court can set is 5 years in prison based upon the agreement. All right. I'm going to follow this agreement and find you have pleaded guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted at this plea hearing to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of the second-degree felony of sexual assault of the 17-year-old, and I am following this agreement. You are hereby sentenced to confinement in the Institutional Division of the Texas Department of Criminal Justice to serve a term of 5 years. You will be given credit for all time you have served in accordance with this case. You will also be required to register as a sexual offender. Those are laws the state of Texas requires. Failure to properly register can result in further prosecution for the requirement of failing to register as a sex offender. Do you understand what has happened today, sir?
Yes, sir.
I just wished you would have had self-control, because you say good things, but yet your actions were different.
That's my past actions, and I guarantee you, not that person. I'm not.
Good. That's good. But, well, there's an old saying, what's in the past is never really in the past. It's still there. It has to be accounted for. Okay. That is all. Thank you.
Judge, could we